distinguished guest, to the James Cook University Law Faculty community, academics and students, activists and peacemakers. Good afternoon. I wanted to start by sharing my appreciation for this opportunity to participate in the James Cook University 2024 Law Seminar Series. It is a real honor and a great privilege for me to share about my journey, which reflects to the current human rights condition in my homeland, Rwanda. May I also begin by acknowledging the traditional custodians of the lands and which you are all meeting on today in Australia. I want to pay deep respect to the traditional custodians of your land, to the elders past, present, and emerging. May I also extend this respect to all First Nation Australians who are part of this webinar. Please accept my sincere appreciation for looking after your beautiful country many Rwandans now call home. I also wanted to take this opportunity to recognize the remarkable contributions of Australians of Rwandan background. Despite of the hardships many of them have experienced, and most fearful to return to their country of origin, I hope they continue to make both Rwanda and Australia proud. I'd like to start with a brief introduction. I am a married mother of 3 children and 4 grandchildren. My husband and the children live in Europe. Sadly, I have not been able to visit them since I arrived in Rwanda 14 years ago, when I came back from the exile to participate in the construction for my homeland and ran in the presidential elections for 2010. It has been a difficult journey. I have missed my children's weddings, the birth of my grandchildren, and I have not been allowed to leave the country to see my husband, who feels seriously ill during my absence. During those 14 years, I spent 8 years in the prison. Although I am now out of prison, I am requested to get permission from the Rwandan authority before I can leave the country. The 6 years since my release, I have not succeeded getting this permission to visit my family, despite my repeated requests to the Minister of Justice and the President of the Republic of Rwanda. I have no doubt in my mind that my plight, enduring a political trial, a 15 years sentence, and the deprivation of my political and civil rights is a direct outcome of the absence of the rule of law in Rwanda. The absence of the rule of law not only has devastating consequences to individuals and their families, but is also a major root cause of conflicts and wars that have claimed millions of lives in Rwanda and the surrounding region. This is why I have always passionately advocated for the rule of law in Rwanda. We must end the cycle of political violence and focus our resources on building a just and fair society rather than repressing political opposition. I wanted to use my personal experience to highlight the stark mismatch between having well-written constitutions and laws and their actual application. If you read the Rwandan constitution, you would be impressed by its promises. However, when it comes to its implementation, there is a significant disparity, as evidenced by my trial and the trials of other defendants, which are seen by the government as being politically sensitive. What did I mean by the rule of law? As is known, The rule of law is built on 3 pillars. First, respect for the hierarchy of norms. Second, equality of citizens before the law. And finally, the separation of executive, legislative, and the judicial powers. These 3 pillars reinforce each other and are essential for a well-functioning society. Each pillar plays a crucial role in preventing the abuse of state power, ensuring that laws are followed by all citizens, including those in power, and safeguarding that legal rights are upheld in practice. Unfortunately, in non-democratic countries like Rwanda, authorities often claim that these fundamental principles are imposed by Westerners. This rhetoric misleading some young people, promoting populist narratives that protect those who violate citizens' rights. I firmly believe that every citizen, regardless of their countries, is entitled to have their rights respected. To illustrate the consequences of the absence of the rule of law, I will share my own experience. In 2010, I was the only woman who dared to challenge President Kagame in the presidential election held that year. After spending approximately 16 years in exile, I turned to Rwanda from the Netherlands in 2010 with the hope of registering my political party, FDI, and running as a presidential candidate later that year. Although I had led the political organization for 10 years, I had never faced an accusation from the Rwandan government. That is why proudly decided to return home and run in the presidential elections. I came back to Rwanda with immense hope and enthusiasm, eager to contribute to nation building. Upon my arrival in Rwanda, a concerted effort by government officials and the pro-government people, the New Times, started to tarnish my reputation and paved the way for my arrest and imprisonment. Just one day after landing on January 7th, 2010, I faced allegations of divisionism, genocide denial, revisionism, and more. The Minister of Internal Security, Sheikh Musa Fazil Harerimana, as quoted in the New Times, on January 2010, accusing me of revisionism and genocide denial, citing it as a clear violation of the country's laws. Then, during his speech commemorating the 16th anniversary of the 1994 Tutsi genocide on April 7th, 2010, President Kagame stated that foreigners are imposing hooligans like Ingabire on Rwanda. Shortly after, I was detained and later released on bail. A month later, after my release, the Prosecutor General made the following declaration about me on 14th on May 2010 in the New Times. As I quote, "The prosecution is more specifically concerned with the continuing posting declarations and the newspaper interviews she has been doing. The case against her is not one of robbery in which restraining physical movement would be enough to contain further damage. It is a case of destructive and divisive ideology whose damage does not require physical proximity of the offender." The prosecutor was actually saying that I had to be locked up in order to stop me from having access to newspaper reporters. On 23rd May 2010, in an interview in a Uganda newspaper, the Daily Monitor, President Kagame made the following statement about me. He said, "On our side, we have evidence which has been brought to her attention and about 10 things she has been denying. Now, She's saying that 7 of them are actually true, and this has come as a result of overwhelming evidence that was put in front of her, including the people she was working with, the former soldier in the FDLR, who are here in our hands, who are testifying to this accusation. This woman will certainly be where she belongs, not the outsider who wants so badly Ingabire to be in opposition leader here or later, or be our president where they might wait for a while. This statement not only demonstrated the interference of the executive and the judiciary, but also violated the principle of presumption of innocence, which guarantees that no guilty can be presumed until a charge has been proved beyond reasonable doubt. This principle is provided by the Rwanda Constitution. It is also preserved in the International Covenant on Civil and Political Rights, which Rwanda is a signatory to. The African Commission on Human and People's Rights has also adopted what it called principles and guidelines on the right to a fair trial and legal assistance in Africa, which stipulates that public officials shall maintain a presumption of innocence and that public officials, including prosecutors, may inform the public about criminal investigations or charges, but shall not express a view as to the guilty of any suspect. As you can imagine, I was shocked by hearing the president of Rwanda already declaring that he would be convicted. In the first, I had never confessed anything to the prosecutor, as he stated, and secondly, I had not yet appeared before a court of law. I was finally arrested and sentenced to 15 years in prison by the Rwandan Supreme Court. The charges against me related to speeches I made when I was the leader of the opposition party from 2000 to 2010 when I came back in Rwanda. Those speeches, according to the judges of Rwanda, constituted a crime of spreading false information and harmful propaganda with intent to cause a hostile international opinion against the Rwanda government. This is tantamount to saying that criticizing a government is a crime. The other charge was minimizing genocide against Tutsis, because I had said that to achieve the effective reconciliation in our country, justice should not favor or discriminate against anyone. Hutus who committed the genocide against Tutsis should accept their guilty and be punished. People responsible for crime against humanity committed against the Hutus should face the law, and all victims must be acknowledged irrespective of ethnic affiliation. The public prosecution at the time told the Time magazine that my message was a coded message meant to appeal to ethnic Hutu sentiment, minimizing the genocide against Tutsis, and that the issue was the philosophy behind it, that was not an issue of criminality, but of philosophy. The final charges related to alleged conspiracy against the government. The 2 foreign lawyers who assisted me were also arrested. One of the lawyers, Maître Bonnet, was arrested at the same time as me on 21st April 2010 because he took pictures of police researchers my home. He spent one night in police custody. This was kept secret. Maître Bonnet did not wish publicity around his arrestation. He abandoned the cases he had in Rwanda. Professor Peter Elinda, an American lawyer who came in Kigali to defend me, was arrested and accused of minimizing genocide against the Tutsi. This accusation was based on his positions as defense lawyer of a Rwandan detainee at the International Criminal Tribunal for Rwanda, based in Arusha. He was released on humanitarian grounds. He also abandoned his cases which were related to Rwanda. In 2014, I appealed to the African Court on Human and People Rights. This court ruled in 2017 that the Rwanda government had violated my rights to freedom of expression and to adequate defense. I was released in 2018 by presidential pardon after spending 8 years in prison, out of which I spent 5 years in solitary confinement. This pardon was accompanied by 2 conditions. First, I have to appear before the local prosecutor once a month. And second, I might not leave the country without the authorization of the Minister of Justice. Since my release, I have written 5 letters to the Minister of Justice, asking the authorization to visit my family, but they have been ignored. The latest request was made in May last year, in a letter that I sent directly to the President Kagame, asking him to remove those conditions. This request was done in line with the presidential order on clemency, which stipulates that the grant of mercy herself requests for the lifting conditions by addressing a written reasoned request to the President of the Republic with a copy to the Minister of Justice. He also ignored my request. In February this year, I applied to the Rwanda High Court asking to be rehabilitated, meaning that I would recover my political and civil rights according to the organic law relating to the criminal procedure. The law stipulates that a person can apply for rehabilitation after 5 years, which run from the date of final release or that of release on parole that has not been revoked. Given that I was released in September 2018, I have the right to be rehabilitated. To my surprise, the judges dismissed my request, saying that the condition attached to the presidential pardon ceased to apply at the end of the remaining period of imprisonment, meaning September in 2025. The judges ignored the provisions of Article 256 of the law relating to the criminal procedures, which sets a time frame for applying for rehabilitation, being 5 from the time a person is released on clemency. Instead, the judges relied on the time frame set by presidential order, thus violating one of the pillars of the rule of law, namely the respect of hierarchy of norms. According to the Rwanda Constitution, a law is above a presidential order. This decision denying my application for rehabilitation means I was unable to stand in the upcoming presidential election in July 2024. This decision also exemplifies the ongoing judicial persecution directed at the regime's critics. I feel that although I was released from the physical prison, but I am still not free. Legally, the actions of Rwanda government violate the East Africa Community Treaty, which mandates adherence to fundamental principles of democracy, the rule of law, and the respect of human rights. This is why in May this year, I filed a case at the Eastern Africa Court of Justice, asking the court to hold Rwanda accountable by restoring my right and safeguarding the democratic aspiration of all Rwandans. This case is not just about an infringement on my personal liberties. It is about the systematic denial of the right of all Rwandans to choose their leaders freely. It is about ensuring future stability of Rwanda and the region of Great Lakes. The cycle of political violence in Rwanda and in the Great Lakes region is not due to alleged primitive eruption of ethnic rivalries between tribes and ethnic groups, but it is rather due to the absence of the rule of law, that is, respect of the hierarchy of norms, equality of citizens before the law, the establishment of the separation of executive, legislative, and the judicial powers, democracy, and respect of human rights. The irony of the matter is that all this happening when Rwanda is no co-chair of the Commonwealth and should be leading in promoting Commonwealth values. These core values include belief in the rule of law as an essential protection for the people of the Commonwealth and as an assurance of limited and accountable government and independent, impartial, honest, and competent judiciary, and integrity of the laws of the legislature, executive, and the judicial as the guarantor of the rule of law, the promotion of protection of fundamental human rights, and adherence to good governance. I would like to highlight the warning issued by the Commonwealth Human Rights Initiative delegation prior to Rwanda's admission to the Commonwealth. They cautioned that admitting Rwanda, despite its poor human rights record, would tarnish the reputation of the Commonwealth and confirm the opinion of many people and civic organizations that the leaders of its governments do not really care for democracy and human rights, and that its periodic solemn declarations are merely hot air. It is on record that the government of Australia was one of the countries that supported the admission of Rwanda into the Commonwealth against the advice of the Commonwealth Human Rights Initiative, arguing that membership would encourage Rwanda to raise its profile in respecting human rights. I shared this hope, but I am now extremely disappointed that the situation of human rights record changed. We appreciate the Australian currently holds the Vice Chair of the Commonwealth Ministerial Action Group, tasked with assessing a violation of Commonwealth values and recommending measures to restore democracy and constitutional rule in member countries. I kindly appeal to the Australian government to exert pressure on Rwanda to uphold Commonwealth values. I sincerely hope that Australia will take concrete actions in the upcoming Commonwealth meeting in August this year. As President Paul Kagame stated in his address to the UN high-level meeting on the rule of law, Rwanda has a first-hand experience with how important the rule of law is, and more specifically, the implication of its absence or disregard, that unequal application. That absence destroyed our country in the post-independence decades leading up to the genocide in 1994. It is my firm belief that the Never Again campaign will remain mere rhetoric without the establishment of the rule of law in Rwanda. I am pleased that President Kagame acknowledges the detrimental impact of the absence of rule of law. However, his words have not yet been translated into tangible actions. So, I appeal to you to be part of the movement of the rule of law in Rwanda, and I count on you to put pressure on your government to honor its laws and the member and sponsors of Rwanda in the Commonwealth, to honor any promise of bringing Rwanda to respect the rule of law. Rwandans have suffered long enough under successive regimes led by strongmen who have gained and retained power through violence and that the consequence is weak institutions, some of them having failed to act independently as they are supposed, and most of the power remain in the hands of executive. My journey has been one of relentless pursuit, a quest for the rule of law, democracy, and the unyielding respect for human rights. These pillars stand not just as idols, but as the bedrock upon which durable peace and economic prosperity are built, not just for Rwanda, but for the entire region. Through my experience, I have faced political violence that defies imagination, yet it has only fueled my determination to bring about lasting change. There are many ways you can contribute to Rwanda's journey and support its people. First, advocate. Raise Rwanda's concerning human rights record with your local MPs and relevant institutions. Your voice can amplify the call for justice and accountability. Secondly, provide platform. Offer platform like this one for us to share our histories, experiences, and aspirations. Dialogue and understanding are powerful tools for change. Third, experience of Rwanda rural. When you visit Rwanda, consider venturing into rural areas. Witness the resilience and the spirit of communities beyond the urban centers. Next, connect. Reach out and connect with Rwandan communities in Australia. Your solidarity can bring hope and strength to those who have faced displacement and hardship. And the last, visit my home. When you travel to Rwanda, you are welcome to visit me at my home. It would be a privilege beyond words to extend the warmth of Rwandan hospitality to more Australians. I appeal to you on behalf of Rwandans who endure hardship to lend your prayers, support, and advocacy for Rwanda's quest to democracy, the rule of law, the political freedoms, and development for all. Thank you sincerely for extending this invitation and for standing in solidarity with us.